On the night of August 24, 1814, British forces entered Washington and set fire to the Capitol building, the President's house, and the Treasury. This is in every American history textbook. What is not in any textbook is the specific question I want to ask about that night. Not what burned, but what was saved, and by whom, and under what instructions, and what version of the document that was carried out of the building in the hours before the British arrived was the same version that was brought back in the weeks after they left. The answer to that question is not settled. It has not been investigated in the way it should have been, because the investigation would require treating the document currently held in the National Archives as a subject of scrutiny rather than an object of reverence. And the institutions responsible for that document have, for reasons I have come to understand in a particular way, not chosen to do that. I came to this through a copy dispute, not a political one, a documentary one. I was working through the ratification history of the Bill of Rights, specifically the discrepancies between the enrolled copies held by individual states in 1791 and the federal copy that was treated as the authoritative text in subsequent legal proceedings. These discrepancies are known to constitutional scholars. They are small, most of them. Punctuation, capitalization. The kind of variance that accumulates when a document is copied by hand multiple times under time pressure. Scholars call this the enrollment problem. It is treated as an interesting footnote. I treated it as a starting point, because a document culture that produces variant copies during ratification is the same document culture that would produce variant copies during an emergency evacuation, and the emergency evacuation of August 1814 was the most significant disruption to federal document custody in American history. And nobody, as far as I could determine, had asked what happened to the copies in that disruption with the specificity the question deserved. By the time you reach the end of what I am going to tell you, you will understand that the document currently displayed in the National Archives Rotunda is not self-evidently the same document that was engrossed in Philadelphia in September of 1787, and that the chain of custody between those two moments has a gap in it that the institutions responsible for the document have declined to close, and that the gap contains at least one textual variant, one clause, that appears in no state ratification copy, no contemporary newspaper transcription, and no delegate's personal record of the text as it was agreed upon in Philadelphia. I am not telling you the Constitution was replaced. I am telling you I have found something that requires an explanation that has not been given, and that the absence of that explanation is a choice. Consider the document culture of the founding era before any of this can be understood properly. In 1787, there was no printing technology that could produce an authoritative legal document. Everything was handwritten. The engrossed Constitution, the formal copy signed by the delegates, was produced by Jacob Shallis, the Pennsylvania General Assembly's assistant clerk, working over 2 days in mid-September to produce 4 large sheets of parchment in a clear, formal hand. That engrossed copy was the ceremonial original, but it was not the only copy. And it was not the version that most people in 1787 knew. The text was reprinted in newspapers across the country within days of the convention's conclusion, transcribed from a printed broadside that was itself set from a handwritten copy, meaning the newspaper versions were third-generation reproductions at a minimum. The state ratification copies were made from the newspaper versions and from printed pamphlets, not from the engrossed parchment, which never left Philadelphia and which most ratifying delegates never saw. And when those state copies were compared to the engrossed parchment, as scholars began doing systematically in the 19th century, what they found was exactly what you would expect from a document culture built entirely on hand transcription, variation. Small, consistent with copying error, but present. What is not consistent with copying error is what I found in the federal custody record from the period between August 1814 and the return of documents to Washington in late 1814 and early 1815. There is a man named Stephen Pleasanton who deserves more attention than American history has given him. He was a clerk in the State Department in August of 1814, and he is the person responsible for the evacuation of the federal government's most important documents in the hours before the British arrived. His own account of what he did that night, written in 1848, 34 years later, in a letter to Secretary of State James Buchanan, is the primary source for what happened to the documents. He describes loading the documents into linen bags, transporting them by cart to a grist mill in Virginia, and later to a house in Leesburg. He describes which documents were taken. He lists them by category: the Declaration of Independence, the Constitution, the correspondence of George Washington, the secret journals of Congress, State Department correspondence. He does not describe the condition of what he removed. He does not describe any examination of the documents upon their return. He does not describe any verification process by which the returned documents were confirmed to be the same documents that had been removed. There is something else in Pleasanton's 1848 account that I did not appreciate until I read it alongside the inventory records that the State Department was maintaining in the same period for other federal property: furniture, equipment, official seals. Those inventories describe items by condition, by number, by physical characteristic, and they record discrepancies when items returned from temporary storage did not match their pre-evacuation descriptions. They do this routinely, even for objects of no constitutional significance. The August 1814 evacuation is described in those inventory records in detail sufficient to account for desks and inkstands. The constitutional documents receive a single collective notation in the return inventory: papers returned from Leesburg, custody of S. Pleasanton, condition not described. That is the entire record of their return. One line: for the founding documents of the United States of America. This is the part I keep returning to, because in any modern institution, a bank, a library, a law firm, the movement of important documents requires a chain of custody record, a description of what was removed, by whom, in what condition, a corresponding description upon return. Pleasanton's 1848 letter is the only account we have of what happened to these documents, written 3 decades after the fact, by the man whose professional reputation depended on having done his job correctly. It is not a chain of custody record. It is a retrospective narrative. And the retrospective narrative does not describe the condition of the documents when they came back. The Constitution returned to Washington custody in the winter of 1814. It was not displayed or publicly examined at that time. It went into storage in the State Department, where it remained largely inaccessible for decades. When scholars and officials did begin examining it more systematically in the second half of the 19th century, what they were examining was a document whose condition, the fading, the damage to the parchment, the state of the ink, had already advanced to a degree that made certain kinds of comparative analysis difficult. By the time the document was transferred to the Library of Congress in 1921, and later to the National Archives in 1952, it had been through more than a century of varying storage conditions, and the forensic analysis that might have established, with precision, when the parchment was made and when the ink was applied, analysis using the radiometric and spectroscopic tools that became available in the second half of the 20th century was not conducted in any systematic way that has been made public. This is the part I keep returning to, because the technology to answer certain questions about the document's physical composition has existed for decades. Non-destructive spectroscopic analysis can characterize parchment age within a meaningful range. Ink composition analysis can establish consistency with, or variance from the materials known to have been available at a given time and place. The Smithsonian and the National Institute of Standards and Technology have the capacity to conduct such analysis. A systematic, documented, publicly disclosed physical examination of the document in the National Archives Rotunda has not been conducted, and its results made available to independent researchers. The reasons given for this, when reasons are given, concern the risk of damage from handling and the adequacy of the visual examination already on record. These reasons are not satisfying if you have spent time with the custody gap. And that single line of inventory notation is not the end of the physical record problem. It is the beginning of it. Because the documents were not examined publicly or officially described in detail for years after their return. The Constitution went into a series of storage conditions: rolled, unrolled, moved between State Department locations that archivists in the 20th century have described as damaging. When it was finally transferred to the Library of Congress in 1921 and a more deliberate preservation effort began, the document's condition had already deteriorated to a degree that the library's own reports described as severe. Fading, flaking, areas of loss, and the physical analysis conducted at that point, and at subsequent points up to and including the encasement in the Archives Rotunda, was focused on preservation. How to stop further deterioration. How to maintain what existed. Not on provenance. Not on the question of whether what existed was the same object that had left Philadelphia in 1787. Preservation analysis and provenance analysis are different disciplines asking different questions, and the question that was not asked is the one that matters here. Consider what was happening in Washington between August and December of 1814 in terms of the document community. The British occupation lasted approximately 26 hours. They burned what they burned and left. The city began to rebuild. Federal officers began returning. Documents began coming back from Leesburg and from other temporary storage locations. And in that period of return and reconstitution, a period of considerable confusion, of lost correspondence, of disrupted records, a number of document discrepancies emerged that were attributed to the chaos of the evacuation and its aftermath. Most of these discrepancies were small enough to be attributed to copying error or to the disruption of record systems. They were noted and filed, and in most cases, the post-evacuation version of a document was accepted as authoritative without comparison to any pre-evacuation copy. Because the pre-evacuation copy was presumed to be the same document that had returned. There is a letter in the holdings of the Virginia Historical Society, written in November of 1814 by a State Department official named Clement Dorsey to a colleague in Maryland, whose name I will give you in a moment. Dorsey writes about the document return process in terms that are administrative and routine for most of the letter. Near the end, he includes a passage that I have read many times and that I have not been able to explain away. He writes that in reviewing the returned papers, he has encountered what he describes as a question of consistency between a particular document and the copies he has access to for comparison, and that he has raised this question with the senior officer responsible for document custody, and that the senior officer has instructed him to note the question in his own files and to proceed with accepting the returned document as the authoritative version. He does not specify which document. He does not describe the inconsistency in detail. He says only that the question is noted and that he has been instructed to proceed. The colleague to whom this letter was written is a man named James Pleasants, a Virginia congressman and later governor. His papers are at the Virginia Historical Society alongside Dorsey's letter. Pleasants' response to Dorsey's letter, if he sent one, is not in the collection. What is in the collection is a separate memorandum in Pleasance's hand, undated but filed between letters from late 1814 and early 1815, that consists of a list of what appear to be article and section references, numbered in a sequence that corresponds to the structure of the Constitution, with notations besides several of them. Most of the notations are check marks. 2 of them are question marks. One of them, beside a reference that corresponds to Article 5, the amendment procedure, has a notation in the margin that reads, "In Pleasance's hand, not in the Maryland copy, not present in Pennsylvania record as I have it, not in the Maryland copy, not present in Pennsylvania record." I have spent a considerable amount of time with Article 5 of the Constitution as it currently exists in the National Archives document. I have compared it, with the help of a constitutional historian, whose name I am not using at their request, to the newspaper transcriptions of 1787, to the state ratification copies that are themselves in state archives and that have been photographed and described in scholarly literature, and to the records of the Constitutional Convention debates as preserved in James Madison's notes. The text of Article 5, as it appears in most of these sources, is consistent. The amendment procedure as the delegates agreed to it in Philadelphia, as it was printed in the newspapers of September 1787, as it was described in the ratification debates, is the same across these sources within the normal range of copying variation. There is one feature of the Article 5 text as it appears in the National Archives document that I have not found in any pre-1814 source. It concerns the clause governing the conditions under which a constitutional amendment may be proposed. Specifically, the language describing the relationship between the application of 2/3 of state legislatures and the obligation of Congress to call a convention. The language in the Archives document is not dramatically different from what the state sources show. It is a clause. A refinement, you might call it, if you were inclined to interpret it generously. A clarification of the procedure that could be read as already implied by the surrounding text. But it is not in the Maryland copy. It is not, as Pleasance noted in 1814 or 1815, in the Pennsylvania record as he had it. I am not a constitutional attorney. I want to be precise about that, because the implications of what I am describing, if the textual variant is what it appears to be, are significant enough that I do not want to overstate what I can establish and what I cannot. What I can establish is this. A State Department official in November of 1814 noted a consistency question between a returned document and comparison copies, and was instructed to proceed with accepting the returned document as authoritative. A Virginia congressman, reviewing constitutional document records in the same period, noted in a private memorandum that a feature of the Article 5 text was absent from the Maryland and Pennsylvania comparison copies he had access to. The document currently held in the National Archives has not been subjected to systematic non-destructive physical analysis whose results have been made publicly available. And the chain of custody between September 1787 and the post-evacuation return of late 1814 passes through a 34-year-old retrospective account by the man who loaded the documents into linen bags. This pattern of document disruption followed by accepted return is not unique to the 1814 evacuation. Between 1789 and 1865, the federal government's constitutional documents were evacuated, relocated, lost temporarily, and returned on at least 4 separate occasions. The 1814 evacuation is the most dramatic, but there were document relocations during the Yellow Fever crisis of 1793, a period of capital confusion during the War of 1812's earlier phases, and a brief removal of documents to Philadelphia during an 1800 transition dispute. In none of these cases was a formal verification process conducted and documented. In none of these cases was a pre-removal description of the document's physical condition compared against a post-return description. The acceptance of returned documents as authentic was, in every case, an institutional decision made under conditions of institutional stress, by people whose professional interest was in the smooth resumption of normal operations rather than in raising questions that had no comfortable answer. What was lost in the evacuation of August 1814 cannot be fully enumerated, because the record of what was removed is a retrospective account, and the record of what returned is no record at all, only the absence of any official statement that something was missing. Stephen Pleasanton was celebrated for saving the documents. He received commendation, professional recognition, the gratitude of a government that needed to believe its most important papers had survived. That need, the institutional, political, psychological need to believe the documents were intact and authentic, is the force that closes the custody gap in the historical record. Not fraud, necessarily, not conspiracy. The same force that causes any institution, under stress, to accept the return of something important without examining it too closely, because the alternative, acknowledging that you do not know exactly what you have, is a problem with no good solution. The document is in a case in the National Archives Rotunda. It is illuminated and climate-controlled and visited by millions of people. It is the Constitution. And the question of whether it is the same parchment that Jacob Challis inscribed in September of 1787, in the same text that the delegates agreed to and the states ratified, is a question that the institutions responsible for it have the tools to investigate, and have chosen not to investigate in a way that would produce a publicly available answer. If you know someone who has stood in that rotunda and looked through the glass and felt, under the reverence, a question they couldn't quite form, share this with them. Clement Dorsey's letter exists. James Pleasant's memorandum exists. The custody gap exists. The question was asked in November of 1814, quietly, by a State Department official who was told to note it in his own files and proceed. He proceeded. We have been proceeding ever since.